Mr. Daroni, have you served?
Donna, yes, you have some?
Yes, that's course. Where, madam?
I believe Mr. Bostek can confirm he has received the authority.
Mr. Bosque?
Yes, Donna.
Mr. Bosque, are you ready now?
Yes, you're ready.
Yes.
I would request my colleague, Mr. Omega, to highlight the authorities for the court. I'm with him here.
Your Honor, as my honorable colleague has indicated, I retaliate what he stated initially, that we are vehemently opposed to the application for bond. I will be taking you through the first authority. The High Court criminal case number 108 of 2018 is our authority number 3. The Republic Pastor Sebastiana Mireti Samuel, the High Court of Kenya sitting at Ngeno. Yes, when I start by appreciating the fact that we have a duty when we oppose bonds to demonstrate the court the compelling reasons. Oh. Or in that particular authority, Your Honor, the High Court was confronted with the issues like the ones before you, where the state was supposed to be accused being released on bond and its trial. On page 2 of the authority, where the issue of bail was considered, the one paragraph 12, that High Court sitting at Meru was very categorical that the main issue for consideration is whether the accused will interfere with the witnesses. The nature of the offense and other factors. In our instance case, Your Honor, and looking at our abductee, it is our submission that the abductee has brought out very clearly that the accused herein, if released on bail, is likely to interfere with the witnesses. Yeah. More particularly, the paragraph which you were taken through, that's paragraph 11, which my land colleague has highlighted. It came out, the abduct brought out the issue of the influence of the accused person on those who will be witnesses in our matter. That is evidence which has been given on us by the deponent of that testimony, Your Honor. And Your Honor, to come out very clearly, on the button we need to start so that we persuade you that we have compelling reasons. In the case, in our authority number 4, KK versus Republic, 2017 EKRR versus the Republic, the High Court sitting at Cabranet. The learned Justice Edward M. Moresi asked the opportunity to make a finding on the burden of proof on the prosecution to bring out the existence of compelling reasons just what is now obeyed. Your Honor, that learned judge we were trying to reiterate what is in the bond and the bail policy, bond and bail policy, which is our second authority. It is true we have not supplied it, but it can be found online, where it's stated on paragraph 4 of page 1 on that authority owner.
Which authority?
Of KK versus Republic.
Okay.
The High Court sitting at Cabernet is our authority number 4.
Yes.
Where on paragraph 4 of that authority owner,
Yes.
the judge went ahead to bring out issues on the Kenyan Judiciary Bail and Bond Policy Guidelines, March 2015, in paragraph 8.
Yes.
He clearly stated that the prosecution has served the court on the balance of probability of the existence of compelling reasons that justified now bail. And it is our submission, my lord, from the authority of the deponent, which was shown today, which is in court, which we are relying on. We have brought out evidence on a balance of probability to justify that we have been able to bring reasons that justified now bail. That is interference, inference, and the witnesses being members of Naroko County, where the applicant accused A has a lot of inference. Your Honor, I want to admit here that we are aware that the accused enjoy the right to be presumed innocent until proved guilty. Your Honor, that right is guaranteed to the accused person in our Constitution. But Your Honor, it is our submission that that right must be balanced with the public interest. Which requires that at all times it is in the interest of the public, it is in public interest to have those who are deemed to have committed offenses to be brought to book. Vis-a-vis their right of presumption of innocence. Your Honor, in this innocent case, it is our submission that as you arrive at the decision, you must take into account that justice at the end of the day is done in this case, that evidence is adduced, the accused person is given a right to ask the questions, and a decision is arrived at after all parties have adduced the evidence. But Your Honor, from our adoption, it comes out very clearly that with the inference of the accused person, yes, over and above some of our witnesses, we are apprehensive on a balance of probability that if we do not ensure that we do not ensure that there is no interference by denying the applicant's bond, for the first time the matter will be pending, before the main witnesses testify. Your Honor, it should be noted that we are not saying that the bond should be denied if the matter takes wrong. We are saying it should be denied to the extent some of our witnesses who are apprehensive that they accuse these witnesses, they accuse these supporters may attack them, or apprehensive that the interference may be there, may fear to come to testify. It is on that basis that we ask you to consider these authorities, whose main point is interference of witnesses. And Your Honor, to add on top on the other ground is, at all times, it is in the interest of justice that we restore the confidence in the administration of justice by ensuring that witnesses are not interfered with and they come forward to testify. And if that is not done, the other consequence is the erosion on the confidence in the administration of justice, where the consequences are serious. Your Honor, we will be asking this court that we, as prosecution, are very important public. We will be eager to have this case supposed to have a speedy hearing at the earliest time possible, so that we can preserve the confidence of the administration, restore the confidence in the administration of justice, and ensure the rights of the accused are protected. Your Honor, in the case of KK versus Republic, our authority number 4, Your Honor, I'm repeating that authority. I'll be inviting you to read paragraph 6 of that authority, where the judge went ahead and gave a detailed analysis of the circumstances, more particularly paragraph 7, where the court, in considering whether there will be a likelihood of interference of complainant by accused uncle, and the court held that interference was illegal, because the uncle was in a state of cooperative status. Your Honor, it is our submission that some of our witnesses are the constituents of the applicant, and therefore the applicant accused here, his relations with them may not be the same as this, but can have some relation that he can easily influence them if he's allowed to go home and interact with them. Your Honor, it is on that basis I was asking the court that in the unlikely event you are persuaded, otherwise we will be asking you to allow us have the main witnesses give their testimony, and subsequently the issue of bail can be considered. That will be our request. On the issue of my last colleague's first point, issue which they raised on the issue of supplying of statements and their cost, Your Honor, we would want to point out that as prosecution, we will be asking our colleague to write us with our Nakuru office, send us his email, and by tomorrow on we will be able to send him all his statements, save for the expert evidence, which we may be able to obtain by Monday. And by Tuesday, we will be able, God willing, we will be able to observe him with the entire pocket. And thereafter, including burning on and the time it requires to prepare, we will be willing to start the hearing of this matter. So that the rights of the accused person, freedom of enjoyment of his right, may not be curtailed based on our application. Your Honor, that is on that point. One point I not cover on the seriousness of the offense, my colleague has taken that into account in their drafting. I would be asking you to go through the authorities and go through section 123A of the Criminal Procedure Code. As you can see, as you retire to write your ruling. And also take into account, since we all of us live in this world, the issues of mouth, which are dominating all over in our mind, and the offense, and it is the association thereof, as you consider is right of presumed innocency. It is on that basis, Your Honor, we urge you to dismiss the application on bail, to deny them on bond, as we have proved our case. Under Article 49(1)H, there are compelling reason to warrant the denial of bail as we preserve the integrity of the criminal process, ensuring that all witnesses come to court and give their story. Thank you.
Mr. Kosek, any response?
Yes, Your Honor, I do have quite a number of responses. Your Honor, to begin with, the prosecution has not established cogent and good reasons that is able to meet the threshold for refusal of cash bail. The innocence, the presumption of innocence of the accused cannot be overemphasized. And also the fact that, Your Honor, grant of bail is an absolute discretion of this honorable court. Your Honor, going through the affidavit, you will notice that the prosecution have abandoned some of the grounds mid-air. Your Honor, if you come to paragraph 15, where they are saying the accused is a flight risk. That was been stated in the affidavit, but there is no support when the prosecution was given a chance to make submission. Your Honor, we want to say from the onset that the accused, being a member of parliament who has invested a lot in terms of political investment in his constituency, cannot be a flight risk. Should he miss some sittings in parliament, Your Honor, if he was to leave the jurisdiction of the country, of the court, then he stands to lose. So we are saying that he cannot be a flight risk the way it has been stated in the affidavit. In any event, Your Honor, it is a matter that the court ought to take judicial notice that you cannot fly out of the jurisdiction or in the country without possession of a passport. Your Honor, in granting bail
Repeat that without
possession and presentation of a passport. Your Honor, the accused does not have dual citizenship. And therefore, the only passport he has is a Kenyan passport. Therefore, to ensure that he does not get out of the jurisdiction of Kenya, and the court in particular, he could be asked to deposit his passport. If the court has any fear about him being a flight risk, which, as we have indicated, Your Honor, is not. Your Honor, there is nowhere in the affidavit where the accused has been mentioned to be a person who can potentially interfere with witnesses. We are hearing this for the first time from the submissions of learned counsel. In any event, Your Honor, the witnesses that have been stated on the face of the charge sheet are public officers who are not in any way under the control, supervision, or directive of Honorable Joanna Ngeno, who is a member of parliament, a member of the legislature. He is not an executive. He does not have any control over the witnesses that have been named. Your Honor, the impression the prosecution is giving is that they are very ready with witnesses to align them in, to arrange them in, bring them to court with a view to testify. Your Honor, Mheshimiwa here was in a where it is said that the cause of action arose, or what you would call the scene of crime, was not in his consistency. It was in a place which is in Kilgore's consistency, which is different from Emurua Digil. Therefore, he cannot be said to have influence in a consistency that is not his. The voters there are not his voters. Your Honor, the prosecution in paragraph 12 of the affidavit of one, I believe is Jumbe Brown, states that if the accused is released on bail, it will jeopardize the hearing. Your Honor, we find this to be rather strange, to use very mild words, and with all due respect to the prosecution. We are at loss as to how an accused person can jeopardize the hearing of the case, as stated in paragraph 12 of the affidavit. Your Honor, I turn to paragraph 13, where you are being asked to take judicial notice of several instances of hate speeches, content by person within the public, and effect of utterances that disorder indecent ethnic clashes in Ngong. Your Honor, this is inviting the Honorable Court to make speculation. If speculation, you are being invited to go into an arena of speculating, or it was engaged in a fishing expedition. Your Honor, the prosecution has not indicated the so-called several instances of hate speech, and also the cases. We have not been told even one single case where the state is saying it's prosecuting. Yet, the prosecution is the one that has the control and the directives of prosecutions in this country. So we should have been told at least 2 or 3 cases if it is being said it is rampant. Your Honor, the accused remain innocent until proven guilty. Paragraph 8, we are told that the evidence so gathered is cogent and sufficient to secure conviction. That is not for the prosecution, Your Honor. In any event, in every case, one will believe that by the time the prosecution files a case before the Honorable Court is because they believe they have a strong case that can secure conviction. But it's not them to determine whether...
Just go back. Just go back. Try to be louder. Answer.
Sorry, Your Honor. I'm saying, Your Honor, in paragraph 8, we are being told that the evidence so far gathered is cogent and sufficient to secure a conviction. Your Honor, that is a complete departure of the court processes. It is not for the prosecution to determine conviction. It is the work of the Honorable Court. In any event, Your Honor, in every case that is lodged before a court, one will presume that the prosecution feels that they have a strong case. Otherwise, why would they, in the first place, bring a case against accused person? Your Honor, you are taken through the charge sheet, and looking at the charge sheet, the 2 counts are misdemeanors. A case that does not carry a penalty of more than 3 years in our jurisprudence is referred as a misdemeanor. It's not a felony. So it's not for the prosecution to say that these are serious cases or these are felonies. These are misdemeanors. At the authorities, Your Honor, that have been presented before this Honorable Court this afternoon, you will realize that all of them are for serious cases, that is murder, which attracts capital punishment at worst. Your Honor, I wish to now distinguish this case, these authorities that were presented before you, with a view to convincing you, Your Honor, that these authorities are distinguishable and irrelevant in supporting the prosecution contention that bail should be declined. In the case of Republic versus Sebastian Miriti Samuel, that is a decision by His Lordship the Honorable Mabea. Criminal case number 108 of 2018, you will note in paragraph 16, Your Honor, that the Honorable Judge found that the accused person who was before him had already 2 criminal cases that were pending in the Tigania court, which are at the defense stage. In other words, Your Honor, the judge was minded by the fact that the accused person who was before him had been found by the court in Tigania, or the prosecution rather, Your Honor, had established a prima facie case against the accused in the court in Tigania. Going on that, Your Honor, one will feel that this was a serial criminal suspect, and that's why the Honorable Judge declined to give bail. This case, Your Honor, is distinguishable. We have not been told that Joanna Ngeno has any other pending case, let alone one where the prosecution has established a prima facie case. Your Honor, we urge you not to rely on this authority and to find that the authority actually supports our application for bail. In number 18, Your Honor, the judge found that paragraph 18, I have noted the prepared report. Your Honor, the judge had the advantage and the benefit of a prosecution or a prosecutor who was able to present a pre-bail report. Your Honor, this afternoon or this day, you've not been presented with one in order to convince you that there was any compelling reasons to have the accused be placed in remand. Your Honor, we wish to go to the case of the case of KK and versus the Republic. In this case, Your Honor, the court found that there must be compelling reasons, and the prosecution must show such compelling reasons. The prosecution today is just talking on a balance of probability, Your Honor. The prosecution is talking about interferences of witnesses. We are not being told whether there is any evidence that, I'm sorry, Your Honor, for going back to issues of witnesses. There is what is called the Witness Protection Program, which is covered by a specific statute. Your Honor, the prosecution has not told us whether they have placed any witness under such kind of protection. Your Honor, a constitutional right in a democracy such as ours requires that the Honorable Court put in several considerations. And in making, this particular case that we've been served with, that is KKK, paragraph 6 of the decision of the ruling is actually put in bold letters and has also been underlined. In considering the question of bail in this matter, the court must balance the right of the accused pursuant to the presumption of innocence to be released on bail pending his trial against the public interest in prevention of crime and access to justice by victims of crime by successful prosecution of offenses, which will no doubt be adversely affected by interference of witnesses. Your Honor, the prosecution appears to have said this in passing, and as I indicated at the submission stage, there is nothing in the affidavit whatsoever where they have even laid any basis, made any attempt as to how witnesses for the state who have been named on the face of the affidavit would be interfered with. Your Honor, in the case of Diana Suleiman Said versus Republic versus Diana Suleiman Said, that is case number 55 of 2014. The other distinguishing factor will be the fact that the prosecution appears not to have completed investigation. In this matter, Your Honor, prosecution is actually raring to present evidence before court. They are on record telling the court that we should come for hearing in the next 7 days, meaning that they are ready to prosecute this matter. But in this particular case, investigations were still pending, and therefore that in itself is a distinguishing factor. And secondly, Your Honor, the court found that there were changed circumstances. The Honorable Court had given bail, but the prosecution was able to convince the court about the changed circumstances. We have not been told about any changed circumstances, Your Honor. We have been told that collection of evidence is complete, and therefore we are talking of a party that is able to prosecute this matter. Your Honor, I now turn to criminal case number 108 of 2018, which was before the Meru Court. Your Honor, not that, Your Honor, sorry, Your Honor. We go to, just give me a second, Your Honor, sorry to do this. The case of the Republic versus Joktan Mayenda, first accused, and there were four accused, sorry. Your Honor, this is the matter that is before, or which was before rather, the Bungoma High Court, being criminal case number 55 of 2009. In this case, Your Honor, the issue of witness interferences featured in prominently, which I do not want to belabor to explain, Your Honor, because this was not put before this court in the affidavit, and it was introduced in the submission. But I want Your Honor to kindly refer you to paragraphs 10, 11, 12, with the title before paragraph 10 stating that possibility of absconding. Your Honor, this case distinguishes the present case, the case that is before you, in the sense that the prosecution had stated that the accused had been hiding in Uganda after the commission of the offense, and there is possibility that he will abscond in his bail, if he is released on bond. Your Honor, the prosecution has proved in a manner that convinced the court that the accused person would have actually been a flight risk, because he was found to have been on the Ugandan, on the Kenya, the other side of the Kenya border, in the Uganda side, hiding. And this is what convinced the court, among other reasons, not to grant bail. In this case, Your Honor, we have said enough that the accused person is a state officer. He's the honorable member for Emurua Division. He cannot be a flight risk. He has a lot to lose, should he be one. And Your Honor, he is a law-abiding citizen, ready and willing to comply with any terms, any bond terms that may be imposed on him by this honorable court. Your Honor, in the said case of Jackton Mayende, the court had been so serious that two witnesses were called in, that is, two police officers, Linus Ouma and one by the name of CN. I don't think there is any other name, but they were subjected to cross-examination regarding the possibility of the accused person absconding the jurisdiction of the court. Your Honor, the opposition by the prosecution has miserably failed to meet the threshold. We urge Your Honor to find that the prosecution has not given any compelling reason to cause this honorable court to decline to place the accused on reasonable bail terms. Your Honor, as we have emphasized, this is a matter for your kind discretion. And we are saying, Your Honor, and also undertaking as counsels, that the accused person will not and does not intend to do anything that will vitiate the bail terms should this court be kind enough to grant. Your Honor, we pray that the accused person be placed on reasonable bail terms. We say no more. Thank you, Your Honor.
So you have presented me with a lot of material. So I reserve the ruling for the 10th of September 2020 at 12 noon. The accused will remain in custody meanwhile.